are going to start to talk about wills now. I view a will as being a very basic and important estate planning tool. You will learn that there's one more kind of plan that's a little bit less sophisticated, if you will, than a will that you put in place yourself, and that's the plan that the state has for you if you don't put a plan in place for yourself. But wills as an estate planning tool really do two things. Number one, it allows you to communicate in writing very clearly who you want to inherit your property when you pass. If you don't do that in the form of a will or another legal document, then the state's plan, which is written by statute, Missouri statute, dictates who gets your property. So it's very important at a minimum to at least take that control yourself and dictate who gets your property in a will. And you do that in conjunction with a couple other concepts like co-owning property or naming beneficiaries on your individual pieces of property. But just as a general rule, with a will, you can name who gets your property. Without a will, you can't, unless you use the beneficiary designations. The other thing that a will does is allows you to name the person who will take charge of your assets and make sure they get distributed. That's called a personal representative. We've all heard that term. Also, executor. Executor used to be more in vogue. Now it's more personal representative, but same thing. And the whole will is pretty much geared toward the judge. I mean, what you put in your will is directed toward telling the judge what you want to happen. And there are two myths that I'd like to debunk today, and if you walk away with nothing else, I would like you to walk away with a better understanding of these two issues. Number one is that a will, if you have a will, you can avoid probate. And you can't. A will has to go through probate in order to be activated. Because essentially a judge is authorizing your personal representative to step into your shoes and to be able to sign all your titles and deeds and everything that you want to pass, authorizing this other person to sign all that for you. And nothing gets authorized without it going through court and the judge authorizing that. So I do want you to understand that if you have a will and nothing else, you are going to probate court. Wills are appealing to some people for two obvious reasons that I'm aware of. They tend to be less expensive than a trust-based plan, and that's partly because they tend to be very simple documents, relatively short documents, easy to prepare. Nowadays, a lot of people go online and download a simple will and get it executed. They're a little bit easier to interact with than trusts. So a lot of people like the simplicity of a will. So less expensive and easier to prepare. A couple things that you might want to consider, even though there's some benefits to having a will, there are some reasons why people, particularly our age, when you've kind of gotten to this stage in life, our lives tend to be a little bit more complicated. We tend to have a lot more assets, more valuable assets, and a lot of people that we might want to think about in leaving our estate. We've got young grandkids, we've got adult children, some of which may or may not be ready to handle an outright distribution. We might have special needs grandchildren. All of those, I don't want to call them complications, but all of those things add a level of complexity to your life that might be beyond the ability of a will to really handle in the way that you want it to be handled. We talked about how it has to go through probate court, and probate is kind of an interesting concept. What's happening is your will has to be filed, and it's essentially filing a lawsuit. You are filing a lawsuit against yourself, or someone on your behalf is filing this big production in court. and paying for it with the money out of your estate. And you're doing that so that your creditors and your heirs get put on notice that money is getting ready to flow through your estate. And the benefit to creditors is it gets published in the newspaper, and they now know that if you owe them money, then they can try to make a claim for it in court during that time that your probate is open. And they actually get first bite at your assets before your heirs do. And the only other people they get paid as early as creditors do are the lawyers, the personal representatives, and the funeral homes. Really, your heirs are last in line to really get what's left over in a probate situation. Distributions, when it comes time to pay the money out that you've directed in your will, those distributions are outright, meaning in a basic will, you're not holding things back and saying, well, until my grandchild who's 6 is 25, I don't want him to really be able to get this lump sum. That's a situation that's better handled in a trust. A basic will doesn't have the ability to really make any kind of contingency plan. You die, it gets probated, those assets get paid out, no matter the age of the person or the situation of the person. So sometimes that's not real appealing, depending on your circumstances. Probate is expensive, and trusts are more expensive than wills, but they're less expensive than probate, typically. Depending on the size of your estate, if you have $15,000 in value of your estate, then probate is very quick and very cheap. If you have $40,000 gross value of asset, it's a little bit more expensive, but still kind of quick and kind of cheap. Once you get an estate that's more than $40,000 in gross value that's going to be moving through the probate court, things slow down considerably and they get considerably more expensive. The creditors are entitled to a 6-month period where you really can't move things forward. So your estate's going to be open for at least 6 months, and I'd say a year to a year and a half is more in line with what usually happens with your average estate. And this is a high estimate, but it's not uncommon for 5.5% to be the amount that is taken from your heirs and put into the pockets of the attorneys, the court system, the newspaper publications, all the costs that go into probating your will can total up to 5.5% of your gross estate. If your gross estate is $500,000, then you could be looking at about a $30,000 fee that goes out in fees to the various sources. If your estate is $1 million, then you could be looking at a $55,000 bill that doesn't go into the pockets of your loved ones. And I want to just make you aware of a couple different ways to think about the cost of a will versus a trust. Wills are a little bit more expensive than doing nothing, obviously. And they're a little bit cheaper than a trust-based plan. But I would like you to think in terms of, if I do a will, and that's relatively inexpensive now while I'm alive, what is the cost of that 5.5% or that 4.5% going to be against whatever size your estate is that is going to be going through probate? You can do a quick calculation and decide, if a trust costs this much, is it still considerably less than what it would cost for my estate to be taxed through probate? I wanted to kind of give you a visual of the probate process that we just talked about. And if this pipe is the probate court, your estate's going to come in one end and it's going to be subjected to attorney's fees, executor fees, appraisals, filing fees, creditors, claims, bond premiums, etc. And it's going to come out in a slow drip on the other side of the process. Like I said, anywhere from a minimum of 6 months to a year and a half on average.